Now, today's ruling was a sharply divided opinion, 6-3, with the court's liberal justices in dissent. In the majority opinion, Chief Justice John Roberts citing a lack of factual analysis in the lower court's previous opinion that rejected Trump's claims of immunity. So the decision will likely further delay a trial on the charges that are pending against him.
Trump's lawyers argued that without absolute immunity, presidents would have to worry about being targeted once they leave the White House. The High Court said a lower court must now decide which of the alleged acts Trump can claim immunity. I spoke with constitutional law professor Steve Wormiel for some insight on the ruling.
One is the president gained a substantial amount of protection from prosecution, from criminal prosecution, for many acts that a president might take that are within his power. And I think a second thing is that the result of this will be that Trump does not stand trial before the election.
Now, on social media, Trump has called the decision a, quote, big win for democracy and said SCOTUS had totally dismantled most of the charges against him.
So our digital investigative reporter Jordan Fisher has been covering this case since Trump was indicted last year, and you've continued to follow sort of the nooks and crannies, every little piece of this case. We wanted to have you here with us again to talk about what this actually means for Trump's case. So Trump himself says that this case has now been dismantled. I'm kind of surprised he used that word. He loves to use the word vindicated. This is not a complete vindication. So is he right? Is the case dismantled?
Sure, Adam. Dismantled, maybe not. Hamstrung, certainly so. So the Supreme Court did a couple things today. One, they said that there's this broad category of official acts for which the president is immune from all prosecution, and there's an even broader category in which he has presumptive immunity. But maybe even more importantly for the special counsel's case, the court said any act for which he has that immunity can't be used in the indictment against him, which means it can't be shown to a jury at a potential trial. They've eliminated this huge category of evidence. If you want to think about something that could mean, think of former Attorney General Bill Barr testifying before Congress and saying that he had told Trump repeatedly that there was nothing to these election claims. A jury will never hear that.
When I was out in front of the Supreme Court covering this in April, I remember one of the things that repeatedly came up was, of course, the November election. And so special counsel Jack Smith's office originally wanted Trump's trial, to start in January. And now the main question are, what are the odds that this will even, make it to trial before the election? Is it even a possibility at this point?
Yeah, Simone, I'd put those somewhere between slim to none. Essentially what the court has done today is sent this back to the lower court to begin the process all over again. That means more arguments, that means more analysis, that means more appeals probably. And it all has to start over again at square one, just determining which of these acts are official and which are unofficial.
So is that what's likely to happen now on in any case against not only former President Trump, but any president in the future, that any possible litigation against them would have to consider that key question first? Is this an official act? Was it an unofficial act? And then by what bar do they decide what's what?
Right. So the district court judge in this case and in any future case is going to have to decide first off if it's within that broader category I talked about of official acts that aren't necessarily constitutionally protected. Does prosecuting that intrude upon the duties of the president? And if so, he has presumptive immunity. And if it doesn't, if it's what you might describe as an unofficial act, they're going to have to figure out how to determine that because SCOTUS didn't give a lot of guidance this time, which is why you can expect it several rounds probably of evidentiary hearings and then appeals again to the circuit and then very likely back again to SCOTUS.
All right. Lower courts they're going to have their hands full at this point.
I mean, this could go up and down through the appellate process for years while they try to decide those key questions. All right, Jordan Fisher, always appreciate your insight. Thank you.